present with me in the Great Hall of Justice, Vice President Gevorgian and Judges Abraham, Sebatinde, Iwasawa, and Nolte. In addition, Judges Tomka, Benuna, Yusuf, Shway, Bandari, Robinson, and Salam are participating by video link. For reasons that have been explained to me, Judge Cansado Trindade is unfortunately unable to be present today. Following the untimely death of Judge James Crawford, who passed away on 31 May 2021, the United Nations General Assembly and Security Council on 5 November 2021 elected Judge Hillary Charlesworth to serve for the remainder of the late Judge Crawford's term of office, which is due to expire on 5 February 2024. We offer our sincere congratulations to our new colleague, who is joining us today by video link, and take this opportunity to welcome her to the court. Article 20 of the Statute of the Court provides that every member of the court shall, before taking up his or her duties, make a solemn declaration in open court that he or she will exercise his or her powers impartially and conscientiously. Article 4, paragraph 2 of the Rules of Court states that the declaration in question shall be made at the first public sitting at which the member of a court is present, and that such sitting shall be held as soon as practicable after the term of office begins. I shall now say a few words about Judge Charlesworth, and I shall then invite her to make her declaration. Judge Hillary Charlesworth, who is of Australian nationality, studied law at the University of Melbourne before obtaining her doctorate at Harvard Law School. She went on to an illustrious career in legal academia. Beginning at the University of Melbourne in 1987, she was named the John Bray Professor of Law at the University of Adelaide in 1993 and served as Professor and Director of the Centre for International and Public Law at Australian National University from 1998 to 2004. She subsequently directed several other schools and centres at the Australian National University, including the Centre for International Governance and Justice and the School of Regulation, Justice and Diplomacy. She has most recently been serving as Melbourne Laureate Professor and Harrison Moore Chair in Law at Melbourne Law School. Judge Charlesworth has taught at academic institutions around the world, including Harvard Law School, New York University, and Université Paris Panthéon-Sorbonne. In 2019, she delivered the prestigious general course in public international law at the Hague Academy of International Law. Judge Charlesworth is no stranger to the court. From 2011 to 2014, she sat as judge ad hoc in the case concerning whaling in the Antarctic, Australia versus Japan, New Zealand intervening. From 2019 until her election to the court, she served as judge ad hoc in the case concerning arbitral award of 3 October 1899, Guyana versus Venezuela. Judge Charlesworth is a member of the Curatorium of the Hague Academy of International Law and of the Institut de Droit International. She is also a former member of the Permanent Court of Arbitration and the Executive Council of the Asian Society of International Law, as well as a former president of the Australian and New Zealand Society of International Law. She is admitted as a barrister and solicitor of the High Court of Australia and of the Supreme Court of Victoria. Judge Charlesworth is the author of a great many publications in the field of public international law, and she serves on the editorial board of a number of international legal journals. I shall now invite Judge Hillary Charlesworth to make the solemn declaration prescribed by the statute, and I request all those present to rise. Judge Charlesworth.
Thank you, Madam President. I solemnly declare that I will perform my duties and exercise my powers as judge honourably, faithfully, impartially, and conscientiously.
Thank you, Judge Charlesworth. Please be seated. The court takes note of the solemn declaration made by Judge Charlesworth, and I declare her duly installed as a member of the court. The court will meet shortly after this sitting at 3 p.m. to deliver its order in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan. At present, I declare the sitting closed. are participating by video link. I recall that on 16 September 2021, Armenia filed in the registry of the court an application instituting proceedings against Azerbaijan concerning alleged violations of the International Convention on the Elimination of All Forms of Racial Discrimination of 21 December 1965, which I shall refer to as CERD or the Convention. The application contained a request for the indication of provisional measures submitted with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court. In accordance with the usual practice, I shall not read the introductory paragraphs of the order, which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall accordingly begin reading of the order at paragraph 13. Armenia and Azerbaijan, both of which were republics of the former Union of Soviet Socialist Republics, declared independence on 21 September 1991 and 18 October 1991, respectively. In the Soviet Union, the Nagorno-Karabakh region had been an autonomous entity that had a majority Armenian ethnic population, lying within the territory of the Azerbaijani Soviet Socialist Republic. The parties' competing claims over that region resulted in hostilities that ended with a ceasefire in May 1994. Further hostilities erupted in September 2021 in what Armenia calls the Second Nagorno-Karabakh War and Azerbaijan calls the Second Karabakh War, which I shall refer to as the 2020 conflict. On 9 November 2020, the President of the Republic of Azerbaijan, the Prime Minister of the Republic of Armenia, and the President of the Russian Federation signed a statement referred to by the parties as the Trilateral Statement. Under the terms of this statement, as of 10 November 2021, I quote, "A complete ceasefire and termination of all hostilities in the area of Nagorno-Karabakh conflict was declared." The differences between the parties are long-standing and wide-ranging. The applicant has invoked Article 22 of CERD as the title of jurisdiction in the present case, the scope of which is therefore circumscribed by that convention. With respect to the question of prima facie jurisdiction, the Court observes that it may indicate provisional measures only if the provisions relied upon by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, Armenia seeks to found the jurisdiction of the Court on Article 36, Paragraph 1 of the Statute of the Court and Article 22 of CERD. The Court must therefore first determine whether these provisions prima facie confer upon it jurisdiction to rule on the merits of the case, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. Armenia and Azerbaijan are both parties to CERD. Armenia acceded to CERD on 23 June 1993, Azerbaijan on 16 August 1996. Neither party made reservations to Article 22 or to any other provision of CERD. Article 22 of CERD makes the Court's jurisdiction conditional on the existence of a dispute relating to the interpretation or application of the Convention. According to the established case law of the Court, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interests between parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. In order to determine whether a dispute exists in the present case, the Court cannot limit itself to noting that one of the parties maintains that the Convention applies while the other denies it. Since Armenia has invoked, as the basis of the Court's jurisdiction, the compromissory clause in an international convention, the Court must ascertain whether the acts and omissions complained of by the applicant are capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the Court has jurisdiction ratio materiae to entertain. Armenia alleges that Azerbaijan has acted and continues to act in violation of its obligations under Articles 2, 3, 4, 5, 6, and 7 of CERT. Armenia asserts that Azerbaijan bears responsibility inter alia for the inhuman and degrading treatment of prisoners of war and civilian detainees of Armenian national or ethnic origin held in its custody, for engaging in practices of ethnic cleansing, for glorifying, rewarding, and condoning acts of racism, for inciting racial hatred, giving as an example mannequins depicting Armenian soldiers in a degrading way at the Military Trophies Park that opened in Baku in the aftermath of the 2020 conflict, for facilitating, tolerating, and failing to punish and prevent hate speech, and for systematically destroying and falsifying Armenian cultural sites and heritage. The court recalls that for the purposes of determining whether there was a dispute between the parties at the time of filing an application, it takes into account in particular any statements or documents exchanged between them. In so doing, it pays special attention to the author of the statement or document, their intended or actual addressee, and their content. The existence of a dispute is a matter for objective determination by the court. It is a matter of substance and not a question of form or procedure. The court considers that the exchanges between the parties prior to the filing of the application indicate that they differ as to whether certain acts or omissions allegedly committed by Azerbaijan gave rise to violations of its obligations under CERT. The court notes that according to Armenia, Azerbaijan has violated its obligations under the convention in various ways. Azerbaijan has denied that it has committed any of the alleged violations and that the acts complained of fall within the scope of the CERT. The divergence of views between Armenia and Azerbaijan regarding the latter's compliance with its commitments under CERT was already apparent in the first exchange of letters between the ministers for foreign affairs of the parties, dated 11 November 2020 and 8 December 2020, respectively, in the immediate aftermath of the 2020 conflict. It is further demonstrated by subsequent exchanges between the parties. For the purposes of the present proceedings, the court is not required to ascertain whether any violations of Azerbaijan's obligations under CERT have occurred, a finding that could only be made as part of the examination of the merits of the case. At the stage of making an order on provisional measures, the court's task is to establish whether the acts and omissions complained of by Armenia are capable of falling within the provisions of CERT. In the court's view, at least some of the acts and omissions alleged by Armenia to have been committed by Azerbaijan are capable of falling within the provisions of the convention. The court finds, therefore, that there is a sufficient basis at the current stage to establish prima facie the existence of a dispute between the parties relating to the interpretation or application of CERT. The court observes that under Article 22 of CERT, a dispute may be referred to it only if it is not settled by negotiation or by the procedures expressly provided for in this convention. The court has previously ruled that Article 22 of CERT establishes procedural preconditions to be met before the season of the court. The court has also held that the aforementioned preconditions to its jurisdiction are alternative and not cumulative. Since Armenia does not contend that its dispute with Azerbaijan was submitted to procedures expressly referred to in the Convention, which begin with a referral to the CERT Committee under Article 11 of CERT, the court will only ascertain whether the dispute is one that is not settled by negotiation within the meaning of Article 22. In addition, Article 22 of CERT states that a dispute may be referred to the court at the request of any of the parties to that dispute only if they have not agreed to any other mode of settlement. The court notes that neither party contends that they have agreed to another mode of settlement. At the current stage of the proceedings, the court will examine whether it appears prima facie that Armenia genuinely attempted to engage in negotiations with Azerbaijan with a view to resolving their dispute concerning the latter's compliance with its substantive obligations under CERT, and whether Armenia pursued those negotiations as far as possible. Regarding the precondition of negotiation contained in Article 22 of CERD, the Court observes that negotiations are distinct from mere protests or disputations and require a genuine attempt by one of the parties to engage in discussions with the other party with a view to resolving a dispute. Where negotiations are attempted or have commenced, the precondition of negotiation is met only when the attempt to negotiate has been unsuccessful or where negotiations have failed, become futile, or deadlocked. In order to meet this precondition, the subject matter of the negotiations must relate to the subject matter of the dispute, which, in turn, must concern the substantive obligations contained in the treaty in question. The Court notes that, as evidenced by the material before it, Armenia raised allegations of violations by Azerbaijan of its obligations under CERD in various bilateral exchanges subsequent to the signing of the trilateral statement in November 2020. In particular, the parties corresponded through a series of diplomatic notes over a period running from November 2020 to September 2021, and held several rounds of bilateral meetings covering the procedural modalities, scope, and topics of their negotiations concerning alleged violations of obligations arising under CERD. The Court observes that between the first exchange between the Ministers of Foreign Affairs of Armenia and Azerbaijan and the last bilateral meeting held, the positions of the parties do not appear to have evolved. Although the parties were able to agree on certain procedural modalities, no similar progress was made in terms of substantive matters relating to Armenia's allegations of Azerbaijan's non-compliance with its obligations under CERD. It therefore appears to the Court that the dispute between the parties regarding the interpretation and application of CERD had not been settled by negotiation as of the date of the filing of the application. Recalling that at the current stage of the proceedings, the Court need only decide whether prima facie it has jurisdiction, the Court finds that the procedural preconditions under Article 22 of CERD appear to have been met. In light of the foregoing, the Court concludes that prima facie it has jurisdiction pursuant to Article 22 of CERD to entertain the case to the extent that the dispute between the parties relates to the interpretation and application of the Convention. The Court recalls that the power it holds to indicate provisional measures under Article 41 of the statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. At the current stage of the proceedings, however, the Court is not called upon to determine definitively whether the rights which Armenia seeks to protect exist. It need only decide whether the rights claimed by Armenia on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The Court notes that CERD imposes a number of obligations on states parties with regard to the elimination of racial discrimination in all its forms and manifestations. The Court observes that Articles 2, 3, 4, 5, 6, and 7 of CERD are intended to protect individuals from racial discrimination. It recalls, as it did in past cases in which Article 22 of CERD was invoked as the basis of its jurisdiction, that there is a correlation between respect for individual rights enshrined in the Convention, the obligations of states parties under CERD, and the right of states parties to seek compliance therewith. A state party to CERD may invoke the rights set out in the aforementioned articles only to the extent that the acts complained of constitute acts of racial discrimination as defined in Article 1 of the Convention. In the context of a request for the indication of provisional measures, the Court examines whether the rights claimed by an applicant are at least plausible. The Court considers, on the basis of the information presented to it by the parties, that at least some of the rights claimed by Armenia are plausible rights under the Convention. In relation to persons that Armenia describes as prisoners of war and civilian detainees taken captive during the 2020 conflict or in its aftermath, Armenia asserts two distinct rights: the right to be repatriated and the right to be protected from inhuman or degrading treatment. The Court notes that international humanitarian law governs the release of persons fighting on behalf of one state who were detained during hostilities with another state. It also recalls that measures based on current nationality do not fall within the scope of CERD. The Court does not consider that CERD plausibly requires Azerbaijan to repatriate all persons identified by Armenia as prisoners of war and civilian detainees. Armenia has not placed before the Court evidence indicating that those persons continue to be detained by reason of their national or ethnic origin. However, the Court finds plausible the right of such persons not to be subjected to inhuman or degrading treatment based on their national or ethnic origin while being detained by Azerbaijan. The Court also considers plausible the rights allegedly violated through incitement and promotion of racial hatred and discrimination against persons of Armenian national or ethnic origin by high-ranking officials of Azerbaijan and through vandalism and desecration affecting Armenian cultural heritage. The Court now turns to the condition of the link between the rights claimed by Armenia and the provisional measures requested. In this regard, the Court recalls that at the current stage of the proceedings, only some of the rights claimed by Armenia have been found to be plausible. It will therefore limit itself to considering the existence of the requisite link between these rights and the measures requested by Armenia. The Court considers that a link exists between certain measures requested by Armenia and the plausible rights it seeks to protect. This is the case for measures aimed at requesting Azerbaijan to treat all persons that Armenia identifies as prisoners of war and civilian detainees taken captive during the 2020 conflict or in its aftermath in accordance with its obligations under CERD, including with respect to their right to security of person and protection by the state against all bodily harm, to refrain from espousing hatred against persons of Armenian national or ethnic origin, and to prevent, prohibit, and punish vandalism, destruction, or alteration of Armenian historic, cultural, and religious heritage, and to protect the right to access and enjoy that heritage. These measures, in the Court's view, are directed at safeguarding plausible rights invoked by Armenia under CERD. The Court concludes, therefore, that a link exists between some of the rights claimed by Armenia and some of the requested provisional measures. The Court notes that pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are subject of judicial proceedings or when the alleged disregard of such rights may entail irreparable consequences. However, the power of the Court to indicate provisional measures will only be exercised if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decision. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the Court makes a final decision on the case. The Court must therefore consider whether such risk exists at the current stage of the proceedings. The Court is not called upon, for purposes of its decision on a request for the indication of provisional measures, to establish the existence of breaches of CERD, but to determine whether the circumstances require the indication of provisional measures for the protection of rights under this instrument. It cannot, at the current stage, make definitive findings of fact, and the right of each party to submit arguments in respect to the merits remains unaffected by the Court's decision on the request for indication of provisional measures. The Court recalls that in past cases in which the CERD was at issue, it stated that the rights stipulated in Articles 5A, B, C, D, and E are of such a nature that prejudice to them is capable of causing irreparable harm. The Court considers that this statement also holds true with respect to the right of persons not to be subject to racial hatred and discrimination that stems from Article 4 of CERD. As the Court has previously noted, individuals subject to inhuman and degrading treatment or torture could be exposed to a serious risk of irreparable prejudice. The Court has also recognized that psychological distress, like bodily harm, can lead to irreparable prejudice. In the view of the Court, acts prohibited under Article 4 of CERD, such as propaganda promoting racial hatred and incitement to racial discrimination, or to acts of violence against any group of persons based on their national or ethnic origin, can generate a pervasive, racially charged environment within society. This holds particularly true when rhetoric espousing racial discrimination is employed by high-ranking officials of the state. Such a situation may have serious damaging effects on individuals belonging to the protected group. Such damaging effects may include, but are not limited to, the risk of bodily harm or psychological harm and distress. The Court has also indicated previously that cultural heritage could be subject to a serious risk of irreparable prejudice when such heritage has been the scene of armed clashes between the parties and when such clashes may reoccur. In the present proceeding, the information placed before the Court by the parties includes the resolution of the Parliamentary Assembly of the Council of Europe on humanitarian consequences of the conflict between Armenia and Azerbaijan, adopted on 27 September 2021, in which the Assembly invoked allegations of inhuman and degrading treatment and torture of Armenian prisoners of war. It also spoke of statements by high-ranking Azerbaijani officials that continued to portray Armenians in an intolerant fashion, and of damage to Armenian cultural heritage. The Court also takes note of the joint statement issued by several United Nations human rights experts who, on 1 February 2021, addressed the situation of Armenians being held captive in Azerbaijan and expressed grave concern, I quote, at allegations that prisoners of war and other protected persons have been subjected to extrajudicial killing, enforced disappearance, torture, and other ill treatment. End of quotation. In light of the foregoing considerations, the Court concludes that the alleged disregard of the rights deemed plausible by the Court may entail irreparable prejudice to those rights, and that there is urgency in the sense that there is a real and imminent risk that such prejudice will be caused before the Court makes a final decision in the case. The Court concludes from all of the foregoing considerations that the conditions required by its statute for it to indicate provisional measures are met. It is therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the rights claimed by Armenia as identified by the Court. The Court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. Article 75, paragraph 2 of the Rules of Court specifically refers to this power of the Court. The Court has already exercised this power on several occasions in the past. In the present case, having considered the terms of the provisional measures requested by Armenia and the circumstances of the case, the Court finds that the measures to be indicated need not be identical to those requested. The Court considers that pending the final decision in the case, Azerbaijan must, in accordance with its obligations under CERD, protect from violence and bodily harm all persons captured in relation to the 2020 conflict who remain in detention, and ensure their security and equality before the law, take all necessary measures to prevent the incitement and promotion of racial hatred and discrimination, including by its officials and public institutions, targeted at persons of Armenian or national or ethnic origin, and take all necessary measures to prevent and punish acts of vandalism and desecration affecting Armenian cultural heritage, including but not limited to churches and other places of worship, monuments, landmarks, cemeteries, and artifacts. The Court takes full cognizance of the representation made by the agent of Azerbaijan during the oral proceedings regarding certain exhibits in the Military Trophies Park, namely, that mannequins depicting Armenian soldiers and displays of helmets allegedly worn by Armenian soldiers during the 2020 conflict have been permanently removed from the park and will not be shown in the future. The court recalls that Armenia has requested it to indicate measures aimed at ensuring the non-aggravation of the dispute with Azerbaijan. When it is indicating provisional measures for the purpose of preserving specific rights, the court may also indicate provisional measures with a view to preventing the aggravation or extension of a dispute whenever it considers that the circumstances so require. In the present case, having considered all the circumstances, in addition to the specific measures it has decided to order, the court deems it necessary to indicate an additional measure directed at both parties and aimed at ensuring the non-aggravation of their dispute. The court further recalls that Armenia requested it to indicate provisional measures directing Azerbaijan, I quote, to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of CERD, end of quotation, and to provide regular reports on the implementation of provisional measures. The court, however, considers that in the particular circumstances of the case, these measures are not warranted. The court reaffirms that its orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The court further reaffirms that the decision given in the present proceedings in no way prejudges the question of the jurisdiction of the court to deal with the merits of the case, or any questions relating to the admissibility of the application or to the merits themselves. It leaves unaffected the rights of the governments of Armenia and Azerbaijan to submit arguments in respect of these questions. For these reasons, the court indicates the following provisional measures. 1. The Republic of Azerbaijan shall, in accordance with its obligations under the International Convention on the Elimination of All Forms of Racial Discrimination, by 14 votes to 1, protect from violence and bodily harm all persons captured in relation to the 2020 conflict who remain in detention and ensure their security and equality before the law. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judges Ad hoc Keith Dode. Against, Judge Yusuf. B. Unanimously. Take all necessary measures to prevent the incitement and promotion of racial hatred and discrimination, including by its officials and public institutions targeted at persons of Armenian national or ethnic origin. C. By 13 votes to 2, take all necessary measures to prevent and punish acts of vandalism and desecration affecting Armenian cultural heritage, including but not limited to churches and other places of worship, monuments, landmarks, cemeteries, and artifacts. In favor, President Donahue, Vice President Gevorgian, Judges Tomka, Abraham, Benuna, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Judge Ad hoc Dode. Against, Judges Yusuf and Judge Ad hoc Keith. 2. Unanimously, both parties shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. I shall now call upon the registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1. La République d'Azerbaïdjan doit, conformément aux obligations que lui impose la Convention internationale sur l'élimination de toutes les formes de discrimination raciale, a, par 14 voix contre 1, protéger contre les voies de fait et les sévices toutes les personnes arrêtées en relation avec le conflit de 2020 qui sont toujours en détention et garantir leur sûreté et leur droit à l'égalité devant la loi. Pour Madame Donahue, présidente, Monsieur Gevorgian, vice-président, Messieurs Tomka, Abraham, Benuna, Mesdames Shway, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, juge. Messieurs Keith, Daudet, juge ad hoc. Contre, Monsieur Youssouf, juge. B. À l'unanimité, prendre toutes les mesures nécessaires pour empêcher l'incitation et l'encouragement à la haine et à la discrimination raciale, y compris par ses agents et ses institutions publiques, à l'égard des personnes d'origine nationale ou ethnique arménienne. C. Par 13 voix contre 2. Prendre toutes les mesures nécessaires pour empêcher et punir les actes de dégradation et de profanation du patrimoine culturel arménien, notamment, mais pas seulement, les églises et autres lieux de culte, monuments, sites, cimetières et artefacts. Pour Madame Donoghue, président, Monsieur Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benouna, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Youssouf, juge, Monsieur Keith, juge ad hoc. 2. À l'unanimité, les deux parties doivent s'abstenir de tout acte qui risquerait d'aggraver ou d'étendre le différend dont la Cour est saisie ou d'en rendre le règlement plus difficile.
Judge Youssof appends a dissenting opinion to the order of the court. Judge Iwasawa appends a declaration to the order of the court. Judge Ad hoc Keith appends a declaration to the order of the court. The text of the order is available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. The court will now adjourn for a short recess before reconvening to deliver its decision on the request for the indication of provisional measures submitted by Azerbaijan in the case concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Azerbaijan versus Armenia. At present, I declare the sitting closed.